Thank you, Mr. Chairman. Under this legislation, it appears that churches, synagogues, mosques, and other religious buildings would likely be considered public accommodations, particularly if they're also open up from time to time to the public for any reason, including for use as homeless shelters, soup kitchens, but for that matter, any public gathering can render any building a place of public accommodation. The language is rather significantly broad and would almost inevitably put this law in a position of occupying a more significant place with respect to religious institutions. Ms. Hassan, I'd like to start with you. Does the Act exempt churches, synagogues, mosques, temples, or any houses of worship from being considered public accommodations?
No, to the contrary. What this does is it expands that definition of public accommodations from the 4 categories that were previously in civil rights law to an almost unlimited number of activities and places that don't even need to be actual physical places. So it includes virtual activities and things like that. So it's very easy for a church that does anything where it opens the doors to the community, which is very much a part of a faith-based mission. It opens the doors for them to be subject to discrimination suits because they're now going to be considered a public accommodation in the same way as a stadium or something like that. So that's one of the most damaging and threatening aspects of this particular act.
Okay, so a church, a synagogue, a mosque, a temple, or other place of worship is now treated under this bill, if it became law, the same way it would be if it were a restaurant or a hotel or a stadium. Now, what about their connected offices? Offices that provide some sort of services, including for use as soup kitchens or shelters. Wouldn't they also be considered public accommodations at that point?
Yes, all of those things would arguably be under this broad sweep of public accommodations.
Okay, so let's suppose, for example, that you've got maybe a mosque or a synagogue that happens to rely currently on federal grants to help bolster security against threats based on religion or ethnicity or maybe both. By virtue of accepting those grants, would the mosque or the synagogue additionally potentially become subject to penalties under this act?
Yes, because they're going to be opening themselves up to being within the parameters of the Equality Act if they're accepting federal benefits or recipient of federal funds, or if they're acting as a public accommodation under this expansive definition. And the key here is, if they are acting in that way, they do not have, under the Equality Act, they do not have recourse to the Religious Freedom Restoration Act as a defense for that. So it's expanding their potential liability and vulnerability, and at the same time pulling away what has been a tremendously important statute for religious people.
Okay, so this is interesting and troubling, especially when you add to it the fact that there are some religious traditions with a lot of followers in this country, including Orthodox Jewish services and many Muslim services, where people sit in different places based on their sex during religious services. So would a Muslim or an Orthodox Jewish congregation be able to continue doing that as they have for, in some cases, thousands of years? Would that suddenly become unlawful if they're places of public accommodation? And if you can't treat people differently based on their sex, what would remain of those religious denominations' ability to continue to worship as they deem fit?
They'd be wearing a straitjacket. They could not live and carry out their faith even within their own buildings under this act. So
we've heard over and over again. We've heard over and over again that this law isn't designed to force religious organizations to change their practices, to change the way they worship. But if what you're telling me is true, Ms. Hassan, those arguments aren't right, are they? In fact, they're very wrong, aren't they?
It's very deceptive, actually, because sure, it doesn't change what we believe, but to be a person of faith is to live that out, to carry it out in action, to be able to, if you believe there should be separation of the sexes, for example, in Judaism or in some aspects of Islam, you need to be able to function like that in all the activities you're doing. So this law, the Equality Act, if it becomes law, is going to redefine what you're doing, anything that opens yourself up as a public accommodation that then imposes on you these obligations to not discriminate on the basis of sexual orientation and gender identity. And then it, at the same time, strips your recourse to the Religious Freedom Restoration Act and puts the thumb on the scale in terms of your ability to cite the First Amendment by putting in the act the idea that this is a compelling state interest. Any claim under this already is a compelling state interest and the least restrictive alternative.
And I see my time's expired, but just to be clear, RFRA is not a get out of jail free card. I mean, RFRA doesn't give every religious institution or person a free pass. It simply forces the government to conduct a certain test, a certain standard of review. Is that right?
Yes, and that's an important consideration here because as Justice Gorsuch referred to in the Bostock decision, what RFRA does is it affords the opportunity for this balancing to occur. It just simply says, okay, we now have to look at this more seriously. There's a burden, but is there a compelling justification? The Equality Act takes that conversation, that delicate balancing right off the table and says, we've already decided that this is just unacceptable conduct. So it flies in the face of both the Bostock decision, which again referenced the importance of RFRA as sort of a super statute, and really ties the hands of religious believers and says, you're not welcome to live your faith in the public square.
Thank you very much. Thank you, Mr. Chairman.
Thank you.